Is it recording?
Yep.
Right, I'm just going live on the YouTube now. So there's 2 videos. If I get out, I might as well get in a wee plug here. All right, hi YouTube, Kate Floss, citizen lawyer, keeping the parliamentarians honest and letting the public know that you do actually have an avenue for taking the parliamentarians to court if you have a question of law. And it's my goal to expose to the public what the courts, the original courts weren't established to, they were never established to prosecute criminals and prosecute people for doing things wrong. Why were the original courts established? They were established so that you would be able to go, you would be able to enter into the court and take hold the parliamentarians to account. That was the original goal of the courts, was to hold the parliamentarians to account, in that the king, all power originally was vested in the religious organizations of the Islamic, the Catholic, and the Jewish religious organizations with the 3 Bibles. All laws come out of those 3 Bibles. But then in 1611, the King James Bible came out, and all the Protestants that were refugees from Germany who had been slaughtered, burned alive, had their tongues cut out, they were called non-Christians. So they actually turned out to be Protestants. What they came up with, and I've got another video, is that the 1688 will of Mary, it's a will. It was the will of Jesus when that came out, that all religions could be protected by these few laws, because that's what it is first in right, best in time. And where did your first rights come from? Your first rights came from God. They didn't come from any man-made thing. They came from God. But God didn't give you a right to a house. God didn't give you a right even to education. God, you were born naked, and God said, go and build your own house, go and learn yourselves, because he gave us free will to go and collect the knowledge ourselves. So that's what we were given. So God didn't give us all of those things. So the rights that we get under the 1688 are very, very limited. There's not many, but they are incredibly valuable. Now, when the courts were established, when that happened, the king handed the power over to the people to govern themselves. He said, you can make any laws that you want, any laws that you want to have, you can have them, as long as you don't interfere with God's almighty rights, because his law, the ancient law, came first. So that's what he said. So that's how Parliament was created. And Parliament is supposed to follow the will of the people, and the will of the people with the 1688 will is in the Cabinet Manual. As long as they're governing us according to that will, as long as they're making laws according to that will, and the courts are going to show it to you in Winston Peters' case. They're going to be showing it to you very soon in Winston Peters' case, which is what we're going to be talking about today, is Winston Peters' case. And so the courts were originally created so that if the parliamentarians were not following the will of the people, if they were making laws that were repugnant to the Almighty, then we as a people would have the ability to go to the court and ask for a declaration and question them, because in the 1688 will, it does say that they should not do anything that would cause us to have question about what they're doing. So as long as they're following those Almighty God laws, there shouldn't be any need for us to call them into Parliament to make questions. And so they're not following those laws presently, and if they're not following those laws, we have the right to make questions. Now, we want to get straight on to Winston Peters, because it's going to be quite a long case, and there's some very great surprises at the end of the case. And you're going to be saying to me, oh, wow, that's really amazing. All right, I'm on the wrong foot. I can stay on there. I think I'll just put, right, hang on. I'll put this one over here, and I'll put that one over there. Turn that one off, and I'll turn that one off. Turn that off. Right, and okay, so I'm going to go to the share screen. what I'm gonna have to do is, because at the end of this case, I've got some really, really big surprises for you. So wait till I get all the background in there and explain it all to you. And then I'm going to explain what all of this means to you. Now, this was done by Winston Peters. Now, this case was ruled on in, right, so I'll go to share screen. And I'm going to have to read it for the viewers on you. Oh, I've gone to the wrong place. Oh, where's share screen? So this is probably the most important case that you're ever going to know about. It is the top case. Print it, study it, know it like the back of your yard. Know it like you know your own body. Know this case. So I'll put that on. So I just have to move these things. Can everybody see my screen share? Now I'm going to go through this case piece by piece. And so this case here, now what you'll see here is this case is by a man called Brian Douglas Staples and a place called Claims Resolution Services. And the defendant that they prosecuted was a man called Richard Logan Freeman. Now this case itself, the case here that it's talking about is absolutely nothing to do with what this case is actually about. And so I have to explain, you don't need to know what this issue was between these people, but if you go down here and you look here, you'll see here that there was a hearing on the 1st of November between SD Carter, that was for the plaintiffs, and these are the plaintiffs here. This is a new court case. So what you see here at the top is the old court case where it says Brian Douglas Staples. You know what I've got to do? I've got to copy this and then I've got to post it on the YouTube. That's what I've got to do. I meant to put it in there. What bits can I take out? I'll take it out from, I don't think I can take out, can I take out the HPS? Norm, are you on YouTube? Norm, can you get onto that? I wanted to post this up. Are you on there, Norm? Not Norm. Right, so that is the legislation. Oh, I've copied the wrong thing, I think.
Yeah, no, I'm on there, but
can you see the court case?
I can see the link. No, wait a minute.
You can't click it.
Okay. I don't.
Can you click it?
Nah, it won't click. Yeah, no, I've tried clicking it, it won't link.
Hang on. I'll go to, that should be coming up live on the channel, right? Oh, it doesn't until I finish. Oh yeah, Winston Peters. Right, is that me? Ah. And I think I can put it, oh, I can't. No. Hang on, I should be able to delete some of this.
The parliamentary privilege links come up.
Yeah, that's come up. I'm only allowed to post 200 characters. So I'm just seeing which characters that I can get rid of to post it. Ah, does that come up? Oh, no, it comes up page not found.
Yeah, page not found.
Just add it after the video.
Eh?
Can you post a link into YouTube in 2 parts? Just do the first part and then the second part. Then we can put them together and then click into it.
Can I do that?
Yeah, just give us the first half and then the second half. We'll put them together and click the link.
Oh, all right then.
There's one way around it.
Yeah, we've got to be creative here, don't we? Right, here is. There's the first part. Did that come up? Oh, it doesn't come. That's the second part. Has that worked out right? No, I've done it wrong. Hang on. Let me delete all that. Remove. And I'll just remove these. Sorry to all those people that are watching, but I want to try and put this up for you so that you can all right. Right, and then I'll stop that at the space store. All right, there's that. Oh, shit. It just comes up the justice. And then you get page not fat. No, you can't split it.
Can you copy just the first, when you highlight it, just copy down to the end of service, bring your cursor back. Bring your cursor back in that part.
Oh, shit.
Oh, where you gone now?
Now I've lost it completely. What about if I just copy this? Can I just copy this here?
Yeah, it looks like a PDF.
Yeah. What about that? Does that work, Norm?
Let's try.
Or what did you say, Jody?
See how you're highlighting the whole lot? If you go from the beginning of forms and go past to, the end of service, can you do that and then post that part, then come back into this screen again and go from the end of that to the rest?
No, because it comes
Like
up
that.
to the justice. Yeah.
Yeah,
It's
copy
come
that.
up to it come up to the justice. And then so it doesn't come up
How
with
important is this to share? Like, is it really important?
It is kind of because, all right, well, we'll just let them watch it later on the YouTube.
Yeah.
It's easier to look at if you can see it, but oh well. If anybody can think of a way, help us. Anyway, let's just get going here. So this case was between Brian Douglas Staples and the Claims Resolution Services. But what had happened is, I'll just give a little bit of background to this case. What had happened is that Brian Douglas had had prosecuted Richard. Well, he hadn't. He wanted to prosecute a firm, but he went and asked Richard Freeman, who was a worker at the firm, asked him if he would come and be a defendant in this case so that they would be able to prosecute it, which was a bit weird in the first place. You can't prosecute a case unless you've got a defendant, or you need two people to prosecute a case, and they didn't have a person to prosecute the case. So they went and asked Richard Freeman if he would join in, and Freeman said yes. All right. Now, here's the background. After they did that, Richard Freeman got a whole lot of documents and he gave them to Winston Peters in Parliament. And when he gave them to Winston Peters in Parliament, after the statement of claim had already been filed, where Winston and the parliamentary speech were not even mentioned because it had not happened yet, after the case had already been filed, Winston Peters made a speech in Parliament using the documents that the defendant, Richard Freeman, had given to him. When they went to court, the Brian Staples entered an extra memorandum against Winston Peters and against the parliamentary speech that he made. And then, and so Winston Peters said, there were two issues. One of the issues was Winston Peters says, I wasn't even there. So how could you basically prosecuted me for something that I wasn't even there to defend myself? And so he's asked for a recall because of that issue. The other issue was that the parliamentary speech was made after the original statement of claim was made. And so there were questions about whether the actual case could even use the parliamentary speech because it wasn't in the original statement of claim. So everything has to be in the original statement of claim. That's why we're lucky, because you know the best thing is when you're doing your law like I've done, I put everything in there. I put as much in there as I can, and you don't lose any points for putting extra stuff in there. It does get a bit distracting. However, if you want to use it, you can. But if you don't want to use it, that's all right. But if you haven't put it in the first statement of claim, you're not able to bring it up at a later date because it wasn't in there. Because otherwise people will start out a case prosecuting one thing and end the case prosecuting something else. The judge is only allowed to rule. Now, everybody remember that, of course, I'm not a lawyer. Look at me. Do I look like a lawyer to you? I'm not a lawyer. I'm just the person that believes in our 1688 will and marry. And I've got a case in the court and I'm following the cases to help my case in the court. So obviously I'm not a lawyer. So that is what has happened. So Winston Peters, can everybody see my thing here? There, is that better? Right, I've made that quite big. So what you'll see here is you'll see the plaintiff of Brian Staples and claims resolution. You'll see the defendant, Richard Freeman, but then you'll go right down here and you'll see these words here, the counsel, S.D. Carter for the plaintiffs, and B.P. Hendry, S.T. Patterson, and the Right Honourable Winston Peters, who was a non-party to the original case. He had nothing to do with it, and yet they made a ruling against him. Now, guess who's involved in the case for the counsel of the non-party is P.J. Gunn. P.J. Gunn is the one that had my case thrown out of the court because of the Mannix law, who I appealed to, which has become a case wanting to get the fees out so that we should be able to go to court in regards to Parliament. We should be able to go to court and not pay fees. So that was all done by Peter Gunn, who was involved with this case with Winston Peters, right? So Winston Peters asked for a recall because he said, I wasn't even there. So how the heck could you make a judgment against my parliamentary speech when A, it wasn't filed at the time when they applied the original statement of claim, and B, he said the speech wasn't even made when they originally pulled in the court hearing. So they're saying, how could you make a prosecution for a court hearing for something that hadn't even happened at the time that they made the submission? So that's what the mainstay of this case, but that's nothing to do with what we're talking about. We're talking about our ancient laws, and we're talking about what we're saying here is that the Parliament is making laws now, which in the 1688 Will and Mary, it says we have a right to petition to the King about parliamentary failings, and it says that all commitments and all prosecutions for doing so are illegal, all right? And so they said to us, we went to court to get a declaration of right to say that our 1688 Will and Mary continued to be part of the laws of New Zealand and that we were protected. And basically my case was saying that the United Nations has no right to come into New Zealand and rule over any of us if we're subjects of the King, because we come under a different law, we come under the Almighty. And so they decided to make me pay fees. And what I realized was that if we had to pay fees on this, it was going to cost us a lot of money. And in an actual fact, we need to be taking the government to court for many cases, the SNAs, the Five Waters, the 60% of foreigners in our parliament when they're not supposed to be there, the voting rights of 16 all through the UN. There are many, many cases that we need to be taking through to the courts that we're not going to be able to if we haven't got thousands and thousands, hundreds of thousands of dollars to do so. So the first thing I realized is we've got to beat these fees. The 1688 says we don't have to pay, and they made a new regulation that says that we have to pay. So that's what we've been fighting, a new law against an ancient law. And this Winston Peters case is going to explain to you why the new laws are null and void if they are repugnant to the ancient law. This is going to show it to you. So I've made my notes. I hope I can do it justice. I'm not a clever person. I've got a high school education. I don't deny it. I'm proud of my high school education. You know what? If what we get in Parliament is from people with university educations and what we can do on the outside with people with high school educations, quite frankly, I prefer my high school education. But what I'll tell you something, I'm not believing that Parliament don't know. This is a case that was from Winston Peters. They know exactly that they've got these rights and they're deliberately not using them. That's why I'm not believing any one of the rotten sods, because they know. Now, so we're going to start here on, so you've got that background. So we'll go to number 2. So it says here, in determining the application, the court found for the purpose of quantifying damages that a speech made by the Right Honourable Winston Peters in Parliament was defamatory of Mr. Staples. That's what the original court found. And so Winston Peters had lost a case to which he wasn't even there. They made the case of Staples versus Freeman. The speech was made after the case was filed. Winston Peters was not called as a witness or as a party, and yet the ruling was made that the speech was damaging to Mr. Staples, and $350,000 in damages was made to be paid by Freeman to Mr. Staples because of, but this opened up Winston Peters, it opened him up to litigation from them, because they then could have turned around and prosecuted him as well. And he wasn't even a party to the first court, so he asked for a recall of that ruling based on the fact that they made a ruling against him when he wasn't even there, and he wasn't even included in the first case. So the court found that Mr. Freeman arranged for certain district court documents to be provided to Mr. Peters and encouraged Mr. Peters to use absolute privilege to make allegations about Mr. Staples in the speech in Parliament. Mr. Freeman was found liable for the harm stemming from that speech, and in addition, a television program that replayed the speech. All right, so is everybody up to date on that? Are there any questions? Right, so then we go down to 3. Mr. Peters, who was not a party to the proceeding, was granted leave to apply for a recall of the judgment on the basis that neither counsel for the plaintiffs nor the court referred to the provisions of the Act, and the court would have proceeded differently had it been made aware of the Act. Mr. Peters says the judgment is a breach of natural justice. He's talking about Almighty God's laws there. That's natural justice, the laws that come from Almighty God, because he did not have the right to be heard before adverse comment was made about him. So that's what he was saying. So the judge says, I shall deal with the latter point first. Now you've got to go and read this yourselves. I'm not going to be reading it, but I've just made the points that are relevant to our case. Now the great thing is, whatever Parliament uses to protect themselves, and whatever they get a court ruling to give themselves a lot of power, we also can use those court rulings to protect ourselves, and we get to use it as well. So that's why it's quite a good thing. They were jumping up doing the little dance because they got their parliamentary privilege, but we also got our privilege in there as well, and you'll see why soon. Now we want to go to the 1688 Bill of Rights. As you know, it's actually called a will, and it is our will, but we use bill. It never used to be a bill, but we use it as a bill. It's a bill to Parliament, not a bill to us. But we will go to there and look, because I want you to see there's a lot of mistakes about this free speech law. So we're going down here to the free speech law, and then this is very important because you need to read this carefully. It says the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or any place out of Parliament. What does that mean here? Debates and proceedings. That means that anything, this is called parliamentary privilege. Anything that they do in Parliament, anything at all, can't be questioned in a court of law. And it can't be questioned in a place outside of Parliament because they've got the will of the people. But this here is the will of the people here. When they're not, this is in the Cabinet Manual, when they're not upholding it, because they're not supposed to create any questions, because it says it right down here. It says the limitation of the Crown for preventing all questions and division in this realm by reason of any 1990 Bill of Rights pretended titles of the Crown or tikanga laws that are pretended titles of the Crown, and for preserving the certainty and succession of unity, peace, tranquility, and safety, that they should not do anything outside of here that will cause us to have questions. And so if they're not doing anything outside of here, then whatever they do can't be questioned in a court of law. It's illegal for the court to question them. And so that's the separation of court and state and the Parliament, right? But what people miss here is that it says here that the freedom of speech and debates here or proceedings. So freedom of speech and debates, that belongs to us. Or proceedings in Parliament, That belongs to them. Now, people are saying that this is only for parliamentary privilege, but I disagree. A lawyer might tell me differently, but according to this Winston's law, it's for us too, because it was written for us. So freedom of speech and debates, in my opinion, that belongs to us, but or proceedings in Parliament ought not to be questioned in any court of law. That's my take on it. Someone else, the other way that people read this is that the speech only belongs to people in Parliament and the debates only belong to people in Parliament together with the proceedings, and this law is to protect them and not to protect us. I disagree. I think we would have to take that to court, because it does say down here, it does say here that for the redress of all grievances, for amending, strengthening and preserving laws, parliaments ought to be held frequently, but we do claim, demand and insist on all singular premises that their or our undoubted rights and liberties, and that no declarations, no judgments or no proceedings to the prejudice of the people in any of the said premises, these are the premises, ought in any wise be drawn into consequence or examples. They're not supposed to make any law that's repugnant to any of this, because otherwise the consequence is that we will go to the court and we will go to the subjects' liberties to be allowed, and we will ask for a declaration, and that will tell them to stand down, because it says here that is the only means for obtaining a full redress and a remedy is for us to petition to the king. Then that gives us the right to petition the king, and all commitments and prosecutions for such petitioning are illegal. So that's what I'm saying. Now, other people might read it differently. That's how I read it. And so I'm sticking to my guns. We're not supposed to say that word. I'm sticking to my thoughts. So let's get back to Winston here. What he said here is that he had the debates and proceedings in Parliament, and his speech in the Parliament ought not to be impeached or questioned by a court. Now, if we go down here to the pieces, you're going to see that the court has ruled that they can question them. Yes, so that's why we'll go back to here. So where are we up to? I'll just get you back on track here. So he said, Mr. Peters, who was not a party to the proceeding, was granted leave to apply for a recall of the judgment on the basis that neither counsel for the plaintiffs nor the court referred to the provisions of the Act, and the court would have proceeded differently had it been made aware of the Act. Mr. Peters says the judgment is a breach of natural justice there, which he was talking about that, because he did not have the right to be heard before adverse comment was made. The question is whether the court was obliged by natural justice, which is Almighty God's law, to accord Mr. Peters a right to be heard before receiving evidence said to concern him, and or before findings were made concerning his actions. Okay, and so that's the case here. It's like, should they have made a court case and ruled against him? They ruled against another person using his name to get it, right? But what it did was it also opened him up to get a defamation against him as well. So he came forward, and then I want to talk to you about number 6. So I'm going to go and show you a couple of laws here that I want to show you. The law that he was just talking about in section, the law that he was just talking about is that the court would have proceeded differently if it had been made aware of the Act. The act that they're talking about is the Parliamentary Privilege Act, which I was able to put up on the YouTube. And the Parliamentary Privilege Act, can you see it? And what they're talking about, this gave them privileges about facts, liability, and judgments or orders. We'll come back to this later. And then they're talking about section 15, where they're talking about the historical events and other facts, which we're going to come back to that. And they're talking about 16 and the subpart for the avoidance of doubt and does not apply to existing court or tribunal proceedings under Article 9 of the Bill of Rights, 1688. Article 9 is the freedom of speech in Parliament and proceedings. So that is the Article 9 that I'm going to be talking to you about. That will also come under section 32, and then I'll explain about these things later. So this law here came out in 2014, on the 7th of August, 2014. However, his case came out, the original case, I can't remember when the original case came out. So the original case came out, I think it came out in 2016, or it was first filed, I think, before 2016, but after their case had been filed. So this act came out after their case had been filed, all right? So that's what they're talking about here, that they said the court would have proceeded differently had it been aware of that act. But the court were not aware of the act because it was not used in the original submission. And it was not used in the original submission because it hadn't been passed in Parliament at this time. So that was the problem there. So proceedings began. So he says it here. The question is whether the court was obliged by natural justice to accord Mr. Peters a right to be heard before receiving evidence said to concern him, and or before findings were made concerning his actions. So was the court permitted to give a judgment on evidence that was produced about him after the case was filed, where he was not a party to the case, he couldn't defend it, and they had not received any evidence from him directly. Now, I want to teach you about this word here. Mr. Oh, I'm in the wrong place. Oh, shoot. Right, go to 18. Right, let's hope I've got the right. So in another case called Quantum, 2 adversarial safeguards were expressly noted. The ability of a party to call the non-party as a witness so that he or she may respond. So since Winston Peters was not put in as a witness or as a party to the proceedings, nobody could call him, neither the plaintiff nor the defendant, because he was not put into the original proceedings, because the Parliamentary Act didn't exist at that time. And secondly, his speech didn't exist at that time. And so it says that did the ability of a party to call the non-party as a witness was so that he or she may respond. That is a criteria about whether a judge is allowed to make a judgment based on a person who is not there. So that's one of the criteria. The second, the role of the judge in assuring fairness, both through exercising the supervisory control over the conduct of the proceeding and ultimate control, the ability to couch a judgment in terms which recognize that a non-party may not have had a fair crack of the whip. That means somebody that was not involved of it didn't get a fair crack of the whip to put their views forward, right? And so that was the criteria that they were looking at. Then if we go to 19, here the court had submissions and evidence from only one party. Now here's the kicker on this. The defendant, Freeman, who was asked to be a defendant, he volunteered his name to be the defendant, and then he didn't turn up to court. He wasn't even there. So I'm looking at all of this as being a bit fishy. The plaintiff made the court case. The defendant, by his own volunteering, said that he would be a defendant. He could have denied it. He said that he would be a defendant voluntarily. And then he didn't even turn up to court. So the court had submissions only, and he didn't put in any evidence, and evidence from only one party. So the level of inquiry and safeguard created by the adversarial process was undoubtedly less. This also made it more difficult for the court to exercise its supervisory control, and exacerbated the existing challenge of drawing the line between a necessary finding and a gratuitous one. Don't worry about that too much. It only just means, basically, we're just saying that the court couldn't make a fair ruling against anybody because they only had the evidence of one party, and then they were only able to make their ruling based on the additional evidence later by the one party on Winston Peters and his speech and the Parliamentary Act. So 22. So preliminary issue, does the Act apply? They're talking about the Parliamentary Act. When Mr. Peters first signalled his intention to apply for a recall of the judgment, counsel who appeared for the plaintiffs at the formal proof hearing filed a memorandum in which he submitted the Act is not relevant to the case. Now, this is very, very important. What he said was, this is important to us because it's talking about old laws. What he said was, when I made the original submission, this Parliamentary Act didn't exist. So therefore, Winston Peters can't use the Parliamentary Act as a protection against himself because it didn't exist at the time that the court case was entered. So we've got that issue of the entry to the court where the speech had not been made. Then after that, the Act was created. And after that, Winston made his speech. And the first court case was won based on his speech. But now they're saying, but hey, he can't use the parliamentary privilege because at the time that we submitted, that Act didn't exist, and therefore it's not available to be used, because in law, the only time that a law has power over you is from the time that that written law existed. And anything that came before that is null and void because that law didn't exist, so you cannot obey a law. So if they said, write a jaywalking law, so they announced, oh, there's going to be a law about jaywalking, right? But they haven't actually gazetted it. They've just said it verbally. And then you continued walking across the road when you weren't supposed to. And then you got caught walking across the road because the cops knew, the police knew that this law was coming in. So they took pictures of you walking across the road on the 15th of December. On the 16th of December, that law was gazetted as being an official law. And they prosecuted you on the 17th of December. But they were not able to do that because on the 15th of December, that wasn't the law yet and you didn't know it. So that's called, so they're not allowed to do that, right? Now, this is important that you remember this because I'm going to come up with coming back to this to you soon. All right. So, proceedings. So they said, Mr. Peters signaled his intention to apply for the recall. Counsel for the plaintiff said in the formal proof hearing filed memorandum in which it submitted that the act is not relevant to this case because of those reasons that I've just said. Then counsel who appeared for the plaintiffs at this hearing, Ms. Carter, made a different submission. She said, namely, that the act does not apply in this case because the proceedings were commenced before the act came into force on the 8th of August, 2014. Therefore, an initial question for the court, the first question to the court is whether or not the act applies to the present proceedings. Now, keep that in mind. That is very, very important to what's going to be coming up later. So I'll just repeat that. I know you don't like me to repeat, but there are listeners on YouTube that haven't got the visual vices for them to be looking at. So what it just says is that the act commenced after the proceeding occurred and after the apparent crime occurred. So therefore the act doesn't apply. And this is the first question that they're after asking the court. Does the act apply? Right? So then we'll go to 24. And it says here, the question arises because the act is impliedly, if not expressly, retrospective. Now I'm going to stop there and I'm going to ask, I'm not going to embarrass anybody. I don't want to embarrass anyone. I just want to ask anyone here, and we've got everybody in our camp, we're called the ChemEI team now, which has come from Maxine. So we've got, which is still under review by Brent, who's going to review it and decide if we're allowed to do that. So he said he wasn't in on the vote. So we're not allowed to change our Oreo team name until we've had Brent's approval, which is fair. He wasn't there for the vote. We voted without them. Me and Sharon did, actually. Maxine wasn't included in the vote. Me and Sharon made it vote. Anyway, it's neither here nor there. Let's not go off on a tangent. But anyway, retrospective. Who knows what it means before you Google it? Don't be Googling it.
It means after the
Eh?
means after the fact.
Past.
Did you have to Google it?
No,
No.
aware of that word.
It's the
I
past.
had
No,
to
I
Google it.
didn't.
No, I didn't. I know what the word means.
Well, in law, it means retrospective means looking backwards, having reference to a state of things existing before the act in question came in force. In other words, a retrospective law means a law which is made to effect acts, facts, or rights occurring before it came into force. Now, I can't find the one that I was looking at, but what I did go and I did find actually one where it said that if retrospective laws are only able to be made if there were no rights and contracts that were made before the retrospective law that are not existing today. So, who's making all brand? I knew it. That if a company made a contract and certain laws were available, so let's just say that a water company let's just say that a water company hundreds of years ago entered into a contract with certain government officials and tribunals. Let's just say that a contract was entered into. If that contract still existed today, the laws that applied to the making of that contract can't ever be changed. Let's just say you bought a block of land and then someone with their little SNAs come along to you and they said to you, part of that land is going to be for the environment and you're not allowed to use it and you're not allowed to do anything that you want on it anymore. That would be an illegal retrospective law against the contract that you made, because retrospective laws can't apply to existing contracts and existing rights. What they would have to do, which is what they're trying to force you to do, is to sell. They're trying to force you to sign up to a new contract agreeably. So if this is why they're rushing the three waters through. This is why they're rushing the SNAs. When you sign the contract for the new law, you have deleted your old contract. So you need to not allow your councils to be signing. So they cannot make these new retrospective laws in regards to an old contract. You are safe and sound. They can only make it if they write a new contract, get you to agree to leave the old contract and get you to agree to go into the new contract. That's what retrospective.
So if we were to sign a contract for a purchase of land now, Kate, and they wanted to put that new part in, you can actually have that struck out by a solicitor and say, I don't agree. Is that what you're sort of saying?
No. Anybody that's holding existing land in New Zealand, any council that is holding contracts for existing water, any council that's holding contracts for existing lands that was agreed on by the New Zealand natives, that you could use it in perpetuity as long as you're using it for the thing that you agreed to, right? Any of those contracts, they're not allowed to change them, but what they have to wait is for either your councils to agree to close that contract or for you to sell your land and close that contract. And then the new land,
they're doing it with new subdivisions. So say someone's got, 100 acres and they just want to sell off 10 or something like that. Obviously the council, they've got to apply to council for that subdivision, and they're the ones that are putting those SNAs on those titles. So they're saying, yes, we'll approve that subdivision for X amount of land, but you're going to have SNA on that particular piece of land. And then so they agree to that, and then it gets sold off with the SNA. So you can't do anything about it.
Yes. And that's the same with the water council. Somebody should contact every council. I ain't doing it for you. I'm doing enough. And this Winston Peters was sent to me. I'll just give Maxine a shout out. She sent it to me and I've just read it and come up with the ideas and planned it all to tell you. But it's up to you people to get in touch with your councils. So the three waters that's why they're saying to the councils, you sign off. That's why they can't do it without you signing off. So you've got to sign off on the old contract, say we don't want that contract, and then you've got to sign up to the new one. That's why they're offering all this money for the councils. They're buying off the councils to sign up to the new contract because they would not be able to do it without you doing that. But I think you could still battle that in court. I think you could still, because I'm going to come back to you. Oh, there's my fucking husband. Oh, dear Lord, what I'm going to do. Oh, shit. Hang on.
Just quickly answer it and tell them you're busy.
Hello, dear. Hello, dear.
มากี่โมง
สอนหนังสืออยู่
อ๋ออย่ามากี่โมง
ประมาณน่าจะไปไม่ไปวันนี้แต่เดี๋ยวไปพบ4 โมงครึ่ง
โอเคไม่ไปก็ไม่ไปบ้านไม่เป็นไร
ต้องสอน
เดี๋
พิ
ยวไป
เศษ
เอง
วันนี้ขอโทษ
ไม่เป็นไรไม่เป็นไรไม่ไปบ้านไม่เป็นไรเดี๋ยวจะไปเอง
ไปเองก็ได้ เดี๋ยวไปดู
เย่ไม่ใช่คิด
หรือ
ว่าไป
ฉันอยู่
ไป
ที่นู่น
เอง
4 โมงครึ่งแล้วก็ไปได้
ไม่ใช่คิดมาไม่เป็นไร
โอเค
เดี๋ยว
สอนอยู่
โอเค thank you dear
โอเคบายบายเดีย
บ๊ายบาย
bye dear Lord told him I'm teaching told him I'm making money when I'm sitting here for nothing making nothing.
Hey, at least the people that are watching you that call you a racist can't call you a racist anymore, can they?
That's right, my husband's got black doodle. No getting around that. Black. With a wee pink knob. Well, it is. Can't be denied. Pay attention. Stop talking about dicks. Right. Oh, I didn't say that. Right. Oh, now I've lost it. Right. Where are we up to? Yes, so the retrospective law. Now, hang on a minute. The surprises don't end there. I've got a lot of surprises to tell you today, and I'm going to be telling all of you. Now, let's all remember that Winston Peters has done this for you. So he's done a great job. So let's just not forget that. Now, where are we up to? So retrospective, the only times that they can make they cannot ever make they want you to believe that they can change a law, but they can't. They can only change laws that don't affect a right that already existed, or that don't. Now, I'm going to show you another one here where you're being deceived, or where a contract that already existed. So they've got to wait, but I've got, so am I still on my share screen? So retrospective, I can turn off, right? Can you still see my screen? Right, so we're going to go to the 1990 Bill of Rights. Now I'm going to tell you about the Health Act. So this is the new 1990 Bill of Rights. And if you go and look down here, what you'll see here is that there's here where it says here.
Don't forget to say the UN 1990 Bill of Rights.
It is the UN because it says
Yeah,
here.
well, remember to say that so
Yes,
people
that's
know.
right. Yeah, you're right. So this here tells you what this act is for. It says an act to affirm, protect, and promote human rights and fundamental freedoms in New Zealand, but it's the and to affirm New Zealand's commitment to the International Covenant on Civil and Political Rights. But this is not a binding law. This is not a binding law, but you've got to be very careful, because when you go over here, I'll just quickly show this because that's not what we're on about. You'll see that they've sneaked in here. In 1990, they put in freedom from discrimination. And in 1993, they sneaked in the Human Rights Act. And then when they sneaked that in, this is a United Nations law. And you'll go to, this is all to do with the Human Rights Commission that's under the United Nations. And you see it doesn't say New Zealand. It does say New Zealand there. But they can only apply this if they go through the 1990. But if you go to section 5, and then you'll see that they've put the Treaty of Waitangi and the 1990 into here. And then if you go down to section KII, it says that it basically says the desirability of New Zealand becoming bound by any international instrument on human rights. And that's where the SNAs and the waters and the mountains being lost and the national parks being lost, that's all because of this that they've slipped in from the United Nations. And it's saying that we will be bound, so they can make any law that they want and we will be bound to it. And that's my original challenge in the court, the original. But the reason why I was able to challenge that was because if you go down here, you'll see it right here. Other rights and freedoms, an existing right or freedom shall not be held to be abrogated or restricted by reason only that the freedom or right is not included in this Bill of Rights or is included only in part. Now that's a sneaky little thing. So it's saying there that if there's an existing right, all right, if there's an existing right, that can't be abrogated, and that comes under the retrospective law that I've just told you about. So all these United Nations laws, all of them are illegal if they're repugnant to our existing right. But what we've got to do is stop signing. This is what they're talking about. This is what those common law people are saying. Stop signing up to them and everything. They haven't quite showing you the actual laws that you can use. So an existing right or freedom. Now, the Yardley case that went to the court, they turned around and tried to use the International Covenant on Political Rights and the United Nations Charter, International Covenant, because they said that was already an existing right, but it wasn't existing in New Zealand. And that's part of my case too, because I've said to them, you've got these two bills of rights, which one would prevail? And so that's all part of my case, which is very complicated, but I'm just Kate Floss with a grade 4 education, trying to fight the mountain that I'm trying to David and Goliath in the court with all the lawyers. I'm sure that a lawyer could do a better job than what I can, but at least someone's doing it, so I'm not going to be ashamed of myself. But anyway, so this is talking about any existing rights. So all these things that they're saying to you about the discrimination and all of that, they can only have that as long as it's not repugnant to our New Zealand existing right that we've had since 1840. And January 14th, 1840, when Queen's Law came to New Zealand, that exists for us. That was the contract when we were emigrated into New Zealand. That was the contract that the natives made with us. So we're outside, we are actually outside of the Health Act. We are actually outside of the SNAs. We are actually outside of the three waters if we so choose to be. But it's up to us not to sign up to these contracts. So that's where that sits there. Very, very important law, Section 28 of the 1990 United Nations Bill of Rights, which is not our 1688 Will and Mary. And a retrospective law would always be overridden by the ancient laws because of, not because of these, but because of the retrospective. Now let's get back to Winston. Now that's, I wanted to talk about that retrospective. So we've done that, 24. And then here's where it talks. Although there is an operative presumption against retrospectivity established by S12 of the Legislation Act, we're not looking at that one. The courts will find an act retrospective even in the absence of express words if Parliament's intention is clear. So if Parliament's intention that a law is retrospective, if it shows, if they can clearly see that it is a retrospective law, then the courts will find it to be retrospective, whether they say so or not. And then it says here in Part 16 of the Parliamentary Act, which we can go to, I'll go to view whole, which is always better. And then we'll go to part 16. So subpart is for the avoidance of doubt and does not apply to, have a listen, does not apply to existing court or tribunal proceedings. So any tribunal proceedings at the Waitangi Tribunal or any court proceedings that had already been done and have not been repealed. So they need to be repealed. If they haven't been repealed, then they exist. If they've been repealed, then they no longer exist. So any law that was created that was not repealed by either the tribunal or a court is existing. And so this subpart declares and enacts for the avoidance of doubt the effect that Article 9 of the Bill of Rights 1688 had on its true construction before this Act's commencement. However, in accordance with Section 32, this subpart does not apply to proceedings in a court or a tribunal and that commenced before this Act's commencement. So that they're saying that these parliamentary privileges still apply. So you see here, parliamentary privileges are in here on the free speech, right? But although they have parliamentary privileges, these are all our rights too. So you can flip it round to say, well, if you can use it for your parliament privileges, we also can use it as part of our existing rights. So that it says there that in the 1688, the true construction was begun there before this Act's commencement. And then it says, when you go to Section 32, which is here, existing court or tribunal proceedings, this Act's provisions, other than this section, do not apply to proceedings. So every section in here applies to all proceedings in Parliament except for our existing right, which is here. Parliament only gets one existing right. That's it, the only one there, so that they can enforce the will of the people. All the rest of the rights belong to us. So they only get that one right. And then all the rest are orders of how they should govern us. So going back to here, the subpart declares and enacts for the avoidance of doubt the effect that Article 9 of the Bill of Rights 1688 had on its true construction, which is the original construction in 1688. And then Section 32 says the entire Parliamentary Act applies except for in regards to this section of the 1688, but that can be applied to us as well. Does everybody understand that? How that applies to us? If it exists for them, it still exists for us in all the other areas. So a further saving is contained in S32, which states existing court or tribunal proceedings, this Act's provisions other than this section do not apply to proceedings in a court or a tribunal and that commenced before this Act's commencement. So any of you that have got existing contracts, hang on to them for dear life. They're not allowed to change them. Now, if you get the subdivision, I would challenge that because they're not allowed to subdivide it either. Because that would all come under your forfeiture of person. This is a grant. when you bought your land, you were given a grant from the Queen. And then any forfeiture of particular person, you are the particular person that was given that grant, and before any conviction are illegal and void. So they're not allowed to give you a land grant and then subdivide it into a separate land grant and give you a different, so you've got to hang on to the whole package. The minute you let part of the package go, you've basically signed a new contract under the new law, in my opinion. But if it was done deceptively without your knowledge, and you can prove that they knew about it and you didn't know about it, well, that would come under deception, because when you sell your house, right, and if you know that you've got foundational problems that are going to cost thousands upon thousands of dollars to fix, in fact, you probably just have to pull the whole house down. If you can prove that they knew about it before they sold you that house, they have to pay you all the money back. They have to give all the money back that you paid, and they have to pay all the compensation and everything. So even if you've signed up to one of these things and you want to change it, then you can do that, because it was deceptive what they did, because you didn't know. So that, and you would not have known. So so that's forfeiture of persons. Now get back, pay attention. So so that's what the Great Reset is about. This is what the reset is that we've got a law and we've got protections, and what they're trying to do is to get us out of this law, out of this protections. They've given us the alternative of the United Nations, where we have no power to stop them from making laws, and we have no protections of our lands and resources. And so that's what they're trying to get you into by the Indigenous nations. They're called the Indigenous nations. They're trying to get you to sign up to a whole new contract so that you lose your old contract. That's what they're trying. That's what the reset is. That's what it is. 26. The Act declares that the meaning of Article 9 of the Bill of Rights, 1688, such declaratory provisions are normally deemed to relate back to the time of commencement of the Principal Act. In this case, the Bill of Rights, 1688. Now see what it says, and thus it covers all matters that happened after that time. Because it says here, in the subject's liberties to be allowed, and the same in all times to come. And so this is a document that can never ever be removed unless they can get you to stupidly sign up to a 1990 United Nations rights, where you have no rights and all the people have the rights over you, and that's why they're beating up on the Anglo people and everything. So so we can keep all of this. So that's where he's just confirmed. He said it covers all matters after that time, and they can't remove it. So Section 27, however, the Act does more than just declare. It specifically provides through SS, all of these ones, I haven't read them, that it is intended to alter the law from that stated in Attorney General versus Lee and Buchanan versus Jennings, which says, by S4, the Act provides it must be interpreted in a way that promotes these purposes. It also states the meaning of Article 9 must be taken to have, in addition to any other operation, the effect required by subpart 2 that I just told you, unless a different effect is required for prosecution of specific offences. Now, wait here. Legislative drafting must achieve the wanted outcome, including any retrospectivity, which is plainly to alter the law in these cases. Now, this here is basically talking about Parliament is protected from any prosecution unless they have made an offence under the Crimes Act. If they've made an offence under the Crimes Act, such as taking money or, you know, having businesses and having government money invest in their business, that would come under a crime under the Crimes Act, and they're not protected by Parliament if they do that. They're only protected in Parliament when they're working on the will of the people and protecting the will of the people and the people's rights. And so in order to do that, they are given this freedom of speech, but we've got it too. So these are all the orders that they have to follow. Now I'm going to tell you, I've already just did a short video, but I'll just quickly mention it here. Let's look at the three waters and let's look at He Puapua. Now, He Puapua was done in the cover of darkness, but how did they pay for all those meetings? Did all those people go to those meetings for nothing? How did they write all the legal contracts and how did they have it all written up? Was all of that done for nothing? No, it wasn't. So it was done under the cover of darkness with government money. And where did that government money? Now, the Three Waters is another example where they planned all the Three Waters. They wrote all the laws for the Three Waters. They had all the meetings for the Three Waters. But where did they get the money from? Well, we know from the Three Waters that they took either 70 million or I'm not sure if it was 70 billion or 70 million they took from the COVID-19 Health Act money that was provided for that. They took that and used it to get all their stuff ready for the Three Waters because they had no money to do it because nobody of the will of the people would have approved it. So they couldn't get a bill passed in Parliament to get the money to use to create the Three Waters project. And that is the same for the He Puapua. Nobody would ever have agreed to give them that money. So they got it from somewhere. We would have to ask where they got the money. Now that comes under levying money. The levying of money for or to the use of the Crown by pretense of prerogative without a grant of Parliament. Without a grant of Parliament for longer in time or in other manner than the same is or shall be granted is illegal. So when they take your money, so you would want to say, where did you get the money to write He Puapua? Where did you get the money, all of that? And you have to ask if that money was gleaned from something that was not granted in Parliament, because we would never have agreed. So it was going against the will of the people. So they did it under the cover of darkness. So that's where the levying of money, but that there is not a crime. That would be a crime under impeachment. But when they actually take money for personal gain, then they don't get their parliamentary privilege and they would be prosecuted. So if you prosecuted the government, called them to the court under this levying of money, right, all of their defense would be paid for by the government. Because the fact of the matter is that they would never have been called to the court if they weren't in Parliament. So all of that is paid, and then if they get lost, they have to leave their position. And then that will be made and they won't do it again. So that is what happens there. But it's very different from an actual prosecution when they've taken money for personal gain, and then that money, they got that money for their personal gain. That comes under the Crimes Act. So they're very different situations here. So you would not be able to prosecute them for this here under the Crimes Act as stealing, because they didn't steal the money. They still used it for the people. They still used it for things, but it wasn't come by the grant from Parliament that said they can use it for that thing. So I'm just letting you know that. So so that it states the meaning of Art 9 must be taken to in addition with any other operation, the effect required by subpart 2, unless a different effect is required for prosecution of specific offences. So specific offences would be the individual that would come under the Crimes Act, and you wouldn't be able to call them through Parliament for that. You'd have to go through the police like everybody else does, right? But when they did an offence that's in regard to our right, since they can use Article 9, well, we can use all the other articles too. There's more than Article 9. Well, then we can use those. The Act through Section 16(1) and 32 saves proceedings already commenced, which would be unnecessary were it not intended to have a retrospective effect. So that's what the court is saying, is that obviously Section 16 and Section 32 in regards only to the 1688 Bill of Rights or the 1688 Will and Mary, in regards to that, the Act doesn't apply. But then it says everything else in the Act applies. So it says this Act's provisions, all of these provisions apply, other than this section do not apply to proceedings in a court. So all their provisions can't be questioned in a court of law, other than in this section do not apply in courts or tribunal. And then that would go back to section, what section was it? We have to know this, we have to know it. And I've lost my section. Section 30. Do you know the section? Damn it. 16, all right. Section 16 is the 1688 Bill of Rights. And then section 32 section 32 is saying that this Act's provisions, other than this section, do not apply to proceedings in any court or tribunal that commenced before this Act's commencement. So that the judge said that's how he knows that the 2014 is a retrospective law. That's how he knows that it is, because of that. So that's the judge's evidence that tells him that this is a retrospective law without them saying that it is. All right, is everybody with me there? So then, section 26 says that they date back to the time, yeah. And section 27 says that they must uphold all of that unless a different effect is required for prosecution of specific offences that I just explained. And then the Act through section 16 and 32 saves proceedings already commenced, which would be unnecessary were it not intended to have retrospective effect. So were it not intended to have retrospective effect, then that section 16 and section 32 wouldn't be necessary. So that's how he knows, that's his proof. And then it goes further to say, I find, considering all of the above points, that Parliament's intention was that the Act retrospectively declares the meaning of Article 9 expressly, overruling cases inconsistent with that meaning, the recognised exception to that broad declaration is contained in the savings provisions. The question arising here then is whether the claim fell into the savings provisions. Now, we're not going to talk about that, but what we're going to talk about is that the 2014 says that it only applies to section 9, right? But if that is the case, then it should still be the case for us under the 1990 United Nations. That's also got a retrospective law on there that says our existing rights can't be abrogated. So that has also got a retrospective law in it saying that anything made under the United Nations, if it affects our existing laws, then they can't have it. So that we can actually use that. We don't only be able to have to use that for section 9. Any other laws, any other retrospective laws that are repugnant, because it says in here for all times to come, we would still win it based on that, whether they wrote that they had a retrospective law or not. We would still win based on the contract that was made for us. So we would just have to go and tweak it to be our sections, which is the forfeiture of person without conviction and the levying of money for purposes that it was not approved for. We would be able to use those, and we would still be able to say it doesn't matter what law that they made retrospectively, they're not allowed to do it because they have to follow that, because that's for all times to come. So as long as if we start using this, they're up the creek without a paddle. They really are. Now, so he says, considering all of the above points, Parliament's attention was that the Act retrospectively, and he said, and it's expressly overruling cases inconsistent with that meaning. So it's basically saying here, any cases that are inconsistent with the meaning that is in here. So he's used it for Article 9, but we can use it for all of the others. Anything that's inconsistent can be overruled by a court of law. And then that's what they basically said in their own parliamentary act. That's what they've said. Here's the relevant timeline of Winston Peters' case, which is that on the 11th of April, the first statement of claim, the 11th of April 2014, the first statement of claim was filed in the district court by Mr. Staples' claims resolution as a defamation case against Mr. Freeman. Actually, he made it against the company and the directors of the company. On the 23rd of June 2014, the plaintiffs made the application for a joinder of Mr. Freeman as a party to the district court proceedings. Mr. Freeman agreed to the joinder. So he agreed to go as the person to be prosecuted by them. He separated himself from the other directors, I think, and he agreed to be the person that would go, and he never turned up to court. So they only had one party at the court. He didn't go, so one party won by default, but they only won because of Winston Peters. And on July 2014, Mr. Peters made his speech in the Parliament, which was before any of this occurred, after. Then on the 8th, and then these people here turned around, okay, keep going here. On the 8th of August 2014, the Act came into force. And then on the 12th of August, an order was made joining Mr. Freeman as a party to the district court, proceeding by his consent. 3rd of May 2016, Mr. Staples filed a statement of claim in the court against Mr. Freedom and Media Works for the defamation and contempt of court because they didn't turn up to court. And in that statement 2 years later, the statement of claim included, for the first time, pleadings regarding Mr. Peters' speech and the Campbell Live program. So it wasn't until 2 years later that they threw Winston Peters in there because they had no case without Winston Peters. On the 4th of May 2016, an application was made for the district court proceeding against Ironclad and Mr. Freeman to be transferred. It went into the High Court, which became, why did it go into the High Court? It would never have gone, this case would have sat in the employment court, is where it would have sat. The only reason why it went into the High Court was because the parliamentary speech was called in. And immediately when you call in Parliament, you immediately leave the lower court or the workers' courts, you immediately enter into the Constitutional Court area, which I don't know much about it, but that's where we are. And so they were only able to do that because they had added Winston Peters and the parliamentary speech. Now, Winston Peters was not able to, on the 31st of July 2017, a second amended statement of claim was filed using Winston Peters, and on the 24th of March 2020, a third amended statement of claim was filed. And then it was at this time that Winston Peters I don't know if it says the ruling here, it must have, because I got the ruling of 350. Mr. Henry submitted that the proceeding could have commenced against him. So
Could not have commenced.
yeah, in section 35, the amicus curiae, who was the neutral person in the whole situation, he submitted that it is difficult to reconcile section 16 and 32 as applying the pre-existing law in respect of a claim that did not involve parliamentary matters with the evident purpose of the act and in particular. So he's basically saying, I think, that 16 and 32 as the pre-existing law in respect of this claim, if it didn't involve parliamentary, he said if it didn't involve Parliament, I disagree. He says if it didn't involve parliamentary matters, oh, they've put in a blocker here for us. If it didn't involve parliamentary matters, well, actually it is like I say, that's exactly right. Any parliamentary matters, the pre-existing law applies. But if it's not a parliamentary matter, you wouldn't be able to use older laws, you'd be able to use newer laws. But not in regards to our 1688. So, because 1688 is all about the parliamentarians on what they're restricted on doing. So he says, if it was a pre-existing law that was not included in parliamentary matters, they wouldn't have been able to use it. So it was only the fact that they threw in, the only reason they were able to win the case is because they threw in Winston Peters with his parliamentary speech. And it was the 1688 parliamentary law that allowed them to get that case into the High Court. Otherwise, it never would have got there. And then I don't want to go into too much of that because you have to go and read this case yourself. And so I just skipped through to section 42. The part of the claim relevant to the parliamentary privilege was added in May of 2016. So they added the parliamentary privilege, the part of the parliamentary privilege 2 years later. This part of the claim arose from the underlying facts. Mr. Peters' speech had not been made when the claim was first filed, and the amendment was not simply a new legal argument on the same facts. No earlier statement of claim put any issue of Mr. Freeman's provision of documents to Mr. Peters, Mr. Peters' speech, and the Campbell Life programs. So none of that was in the first thing, it all come later. And then so they tried to use the retrospective law that they could use it. It backfired on them. It all backfired on them because they used the parliamentary orders and everything, and it backfired because of the retrospective thing and all of that. So the purpose of S16 and 32 is to prevent the Act affecting proceedings already before the court. However, there were no issues of parliamentary privilege before the court in this proceeding when the Acts commenced. Indeed, when the proceeding was filed, Mr. Peters' speech had not even been given. So the proceeding was then a defamation action only against Ironclad in respect of an alleged defamatory statement made on a Facebook page. That claim was not and could not have been affected, and nor was any party prejudiced by the commencement of the Act. So their Facebook claim would not have won the case without the Winston Peters parliamentary announcement and without the Winston Peters Campbell Life program. Their case would have fallen flat. And so it was them that needed the parliamentary, it was them that needed the parliamentary act to get their case into the court. But it backfired on them because of Winston Peters turned around and said that, yada, yada, I think you know what I mean. So in section, now I'm going to give you some very interesting information here. This is where I want you to listen to me. Section 18 of the Interpretation Act 1999, in force at the time, stated the effect of repeal on enforcement of existing rights. Now, this is important. Listen carefully. The repeal of an enactment does not affect the completion of a matter or thing or the bringing or completion of proceedings that relate to an existing right, interest, land title or water title, interest in a law or any right or any immunity or any duty. So any enactment, any existing right that you have, any existing title that you have, any existing interest in law that you have for your right, if that is already existing, okay, then our case is huge. If they let us in the court, and I think they should, if only, I don't need a lawyer, but anyway, anything that's existing, even if they repeal an act that has laws to do with the contract that you made, if that is existing and you're still needing to use that to this day, and this is why they flooded the country with immigrants and they're trying to get us out, because they want a new contract with all the immigrants where all the lands and resources are set under the United Nations control with a new contract, and they can't do that with any of us. They need us either dead, aborted, leaving the country, left the country, renounced our nationality. They need us, or bred into. They need us to be not existing for all of these rights to be taken. So what they've done is they're repopulating our countries of England, Scotland, Ireland, Australia, and New Zealand, so that they can put in a whole different set of rights and titles and conditions. And so they're not able to do that completely with us. And that is the Great Reset. So even if they repeal it, it has no effect if we are still living and our children and children's children are living and want to use it. So what they've got to do is they're doing a lot of little sneaky remove things here. A repealed enactment continues to have effect as if it had not been repealed for the purpose of completing the matter or thing, or bringing or completing the proceedings that relate to the existing right, interest, title, immunity, or duty. So that comes under our Settlers Act and our Immigrations Act that we had pre-1949. Anyone with a immigration to New Zealand pre-1949, any of you that are born to that, continue to hold your existing rights under the Treaty of Waitangi and the 1865 Native Rights. And you'll see that in the Parliamentary Act, where it says here, the Parliamentary Privilege Act provides the legal basis for parliamentary privilege. It deems that the privileges held by the British House of Commons in 1865 to be applicable in New Zealand. These privileges include, but not only, but it includes, one of the things that it includes is that for the freedom of speech in Parliament, but it also includes us. So, no, it says, where was I up to? 50, we're almost at the end of our video. So those are our existing rights. Finally, the Court of Appeal considered the competing policy considerations. These were, on one hand, giving effect to Parliament's will, which we know that this is the will of the people is here. And he says, giving effect to Parliament's will aimed at changing the law and introducing new policies. And on the other, protecting, for reasons of justice and fairness, positions already established under the old law. This is my case, because it comes right into it, because under the 1688 and my German Settlers Act, I don't have to pay to go to the court in regards to this Bill of Rights, because it says the right to petition is free. So they have to protect, in fairness, they protect the introduction of new policies. They also have a duty to protect positions already established under the old law of the contract that they made with us Anglo people. They made it with us, and they've got to uphold it to us. That's what I'm saying. That's why the 60% of foreigners in our parliament are illegal, because under our law, the parliament was set up, they had their Waitangi tribe, they had their Maori affairs and their own tribunal in their own language and all their own. That's what they had. We had our parliament with our existing laws, but most of the Maori or not all of them, but they're also half caste. So they got 2 boots in. But all those other people didn't get a boot in. They don't get 2 boots in. They get 1 boot in as a citizen of New Zealand. That's the only boot that they get in. But to get their rights in Parliament, they have to be born here to 2 New Zealand parents. That's the rule. So 60% of our Parliament are not there legally if they're not born to New Zealand, because that's in our supremacy law. So if broadly speaking, how it says here, positions already established under the old law, they found that if broadly speaking, no existing vested or accrued legal interests are put in jeopardy, the new manifestation of the Parliament's will is to be given the full effect. Read carefully. If broadly speaking, this is in a Supreme Court, if broadly speaking, no existing vested or accrued legal interests are put in jeopardy, waters here, 3 waters here, the new manifestation of Parliament's will is to be given full effect. But if the old law legal interests are put in jeopardy, like stealing the water from the New Zealand people and putting it in the hands of a single tribe, if they are put in jeopardy, taking the national parks, all of that, putting it in the hands of a single tribe, if they are all put in jeopardy, then that new manifestation of Parliament's will should not be given full effect. It gets a partial effect, not a full effect, to the point that they're not affecting all the people of New Zealand that have been there for hundreds of years. So that's what that's saying. So you can have
Also-
some things, yes?
Ruling under by division.
Yes,
Doing that.
all illegal,
Mm,
not allowed to do
doing-
it.
doing this. Mm.
And then so we go back, yes, exactly, Jody. So section 62, similarly, the emphatic declaratory terms of S16, that is, that the operative provisions of the Act for the avoidance of doubt set out the true construction of Article 9 of the Bill of Rights 1688, but it should be called the Will and Mary, do not support expansive reading. I really didn't really understand this, so someone might go and have a look at it. I don't really know what it means. I didn't understand do not support an expansive reading. Wasn't sure about it. Someone can go make comments. But under 64, noting the policy approach of the Court of Appeal in foodstuffs, it is difficult to reconcile an interpretation of S16 and 32 as applying the pre-existing law applicable to parliamentary privilege in respect of a claim that did not involve parliamentary matters with the evident purpose of the Act and those provisions in particular. So you can't apply the pre-existing law unless it's applicable to Parliament. You can't apply it for anything else. You can only apply it for Parliament. And why can you only apply it for Parliament? You can only apply it for Parliament because it's always done under this one since the time of its inception for all times to come. And so that sets out everything, and it tells us here, that that no declarations, they cannot make a declaration or a judgment or even do anything or do any proceeding to the prejudice of the people of any of these said premises. Now, the only thing Parliament gets is this. That's the only one that they get. We get it too, but all of this is an order of how they have to behave. We get all of this. That's ours, not theirs. But it is included in Parliament in that their position is rested on them upholding this. And if they don't, then it's a parliamentary matter and we can call them to the court. We're supposed to be able to call them for free to the court because it does tell us that we've got the right to petition the king, or their power is set on the king, and all commitments and prosecutions for such petitioning are illegal. When they prosecute you and order you to pay money, that is illegal, as long as you're using. So that he said that would not apply to all pre-existing laws. Going to 66, the main purpose of the Act is to reaffirm and clarify the nature, scope, and extent of the privileges, immunities, and powers exercisable by the House of Representatives, its committees and its members, and to ensure adequate protection from civil and criminal legal liability for communication of and documents relating to parliamentary proceedings in Parliament. It basically means that, as I've already told you, it means that you can call them to the court only on this. You cannot call them to the court in regards to criminal matters under the Crimes Act. Under that, they get their parliamentary privilege if it was anything done in Parliament, but the Parliament is not allowed to be repugnant to our will. All right, so that is the will of the people. It's not allowed to be, I don't see, so it's not, they're not allowed to go against the will of the people. But if they did something that is not in here, like they went and stole money, that would come under the Crimes Act. And so that would just come under a normal, everyday lower court hearing. So that's what they're saying. He's gone here on to say, which I disagree. One of the subsidiary purposes of the Act is to define, for the avoidance of doubt, proceedings in Parliament. So only proceedings in Parliament we can use it. For the purposes of Art 9, and in particular to alter the law, in the Supreme Court's decision in Attorney General versus Lee, the Supreme Court held in that case that a public servant briefing a minister in preparation for a parliamentary question was not protected by parliamentary privilege. So that is a bit of an anomaly. We'll have to go back and look at that. So I'm not sure if that's true or not, because he said that they held that the public servant, wow, we're not public servants. That's why I like doing these videos, because I get to talk about it. We are not public servants because we're subjects. They're the public servants. So the public servants that are giving this material to the Parliament, they're not protected, but they're protected as subjects. So they would get their protection through that. They'd go back to being a subject. So they, so we've still got it. All right, then. All right, that's just come to me. Right, moving forward. Now I've got the real big surprise for you. Now I've got the big surprise. Biggest surprise of all. Section 70. The words incidental to must be interpreted in context. The impugned material, which I don't know what that means, must have more than just a passing reference to proceedings in Parliament in order for the material to be considered a proceeding in Parliament. So it has to have, it has to have a substantial evidence and issue to show that it came from a proceeding in Parliament for it to have any effect. Section now we're going to go down to section 11. Now, here's quite the surprise. Facts, liability, and judgments or orders in proceedings in a court or tribunal, evidence must not be offered or received, and questions must not be asked, or statements, submissions, or comments made concerning the proceedings in Parliament by way of or for the purpose of all or any of the following. And it goes to list that you're not allowed to question them or relying on the, you're not allowed to question them about their truths. You're not allowed to question them about their motives, their intentions, or any proceedings in Parliament. You're not allowed to question their credibility, their intention. You're not allowed to question inferences, conclusions, or any of the proceedings in Parliament. You're not allowed to question proving or disproving, or tending to prove or disprove in Parliament. And you're not allowed to question any resolving of matters, or supporting or resisting any judgment, order, remedy, or relief arising sought in the court. So you're not allowed to question anything that they do in Parliament according to, but here's the will of the people. Anything they do in the Parliament for the will of the people can't ever be questioned, because they're not supposed to create laws. They're not supposed to create laws. They're supposed to create laws that prevent any questions. And they're supposed to create law that prevent divisions. So when they create laws that cause us to question, and the only ones that we're allowed to question are written in here, they're the only laws that we're allowed to question. So that it says we are not allowed to question, but then if you go to using the language of Act 9, freedom of speech is impeached where civil or criminal liability is sought to be imposed for what a person has said or done in Parliament, whereas it is questioned where legal proceedings critically examine what a person has said or done in Parliament. So what they're saying is that under the section 11, which is here, you're not allowed to question Parliament, and they have questioned Winston Peters about his freedom of speech, and they have impeached him under a criminal liability, and that's illegal because he's allowed to say whatever he wants in Parliament. That's one of the privileges that we all have, that you're allowed to say what you want, and it's not a criminal charge. You can't be charged with it criminally. So, but here's the interesting thing. The prohibition on impeaching or questioning reflects the constitutional separation of powers. Its purpose is to avoid the conflict between the legislature and the judiciary, and to preclude judicial questionings of proceedings in Parliament, as a court has no legitimate occasion to pass judgment on parliamentary proceedings. They can never allow, this is called parliamentary privilege. They never allowed in a court of law to question what they've done in Parliament. So Parliament has taken that to mean that they can make any laws that they like, and the courts have got no power to do anything over it, right? But here's the big surprise that I told you I was going to give you at the very, very end. Section 15 of the Parliamentary Privilege Laws says, he said, Section 15 must be considered together with Section 11. Section 11 says you can question nothing. Nothing at all, even me. But section 15 says, use of proceedings to establish without impeaching or questioning historical events or other facts. So if you're accusing them in a court to establish, you're not impeaching them, you're not prosecuting them, but you're simply questioning them about an historical fact of law in relation to proceedings in the court or tribunal, neither this subpart nor the Bill of Rights 1688 prevents or restricts evidence being offered or received, questions being asked, or statements, submissions, or comments being made. Look at Jodie, she's smiling. She knows what it is. Concerning proceedings in Parliament by the way of or for the purpose of establishing with no impeaching or questioning of the proceedings in Parliament a relevant historical event or another fact. This section is explanatory only and does not limit or affect the prohibition in Article 9 of the Bill of Rights 1688 operating as this subpart requires or independently on impeaching or questioning proceedings in Parliament. So you can question them if they've done anything that is repugnant to that 1688. We're allowed to call them in and question them on the historical fact that they cannot make a retrospective law because of the historical fact said that we can have this, and your new law says that we can't have it. And we're allowed to call them under the 1908, which I'll just show quickly for the viewers. We've got here our 1908 Declaratory Judgment Act. So everything's here if you're not a criminal and you are supporting the people of New Zealand and you're not involved with all of the finances here, that it does say here that where any person claims a right under any statute, by will, deed, document, or manner to be only interested in the construction. You're only interested in the construction or the validity, you're not prosecuting anyone. Such person may apply directly to the High Court, not the lower court, directly to the High Court. You go directly there. You may apply for a declaratory order determining any of those questions as to the construction or the validity of that, and that would mean in regards to the historical facts. So that comes under section 15, use of proceedings to establish without impeaching or question historical events or other facts. You see, Jodie knows what I'm talking about. You all know what I'm talking about. I can see it on your faces. You all know what I'm saying here.
Yeah.
So then, this is our case. This is classically our case. And so I'll be able to use this when I send it to the Supreme Court, which I've only got like 10 more days or something to get it in, but I'm half written. We're almost there. I'll be able to use this because I'm allowed to question them on historical facts. And the new law says that I have to pay fees, but the historical law says that I don't have to pay fees as long as I'm only questioning them on the historical facts and nothing else. I'm not impeaching them, I'm not prosecuting. So I think it all ties in there. If I was a lawyer, I'd be able to put it together very well, but I'm not, so I'll do my best. So then the last bit, we're almost finished. Section 74, parliamentary proceedings. We can thank Maxine. Wow. You can thank Maxine. You can thank, first of all, Winston Peters for putting all this together hugely. So the 1688 has already been called. It's in, it's back. thank Winston Peters for creating a case. Thank Maxine for sending it to me. And we can thank Kate Floss for researching it for hours and hours and tying it all up into our case and into the Three Waters and into the SNAs and all of that and how we can use it. And it's just a matter of us figuring out how to do it. Well, not me, all of you figuring out how you're going to do it. It's not going to be an easy thing, but it's certainly doable. We know that it is. Now, 74 parliamentary proceedings can be considered and commented on in court for the purpose of establishing, it says it again, this judge has ordered this. The judge said parliamentary proceedings can be considered and commented on in court for the purpose of establishing a relevant historical event or other fact. That's my 1844 ordinance of the German settlers. The embargo is only triggered if the parliamentary proceedings are impeached or questioned, but they can't be parliament questioned as long as their proceedings are not repugnant to the ancient law, then we're not allowed to question that. But the minute that it comes up repugnant to that, that's why they can't write laws that are repugnant. So, there's a woman in our meeting with no camera. Is she gone now? So that's about the end. So the judgment there, the main bit, what there was, that as long as we're not impeaching them, and as long as we're not questioning their laws, as long as that law that they've made is not repugnant, we're not allowed to question that, but we're allowed to question if there's a conflict of the ancient law and the modern law. And that's my case. You know, I may not have written it so perfectly, but what I'm claiming is that Human Rights Act, that New Zealand will be bound to any international instrument. I'm saying that that's repugnant under the supremacy law, because I better just show the supremacy law one more time, because that I'll just show it one more time in the 1688. Under the supremacy law, it's here in the supremacy law that I do declare, under the supremacy law, I do declare no foreign prince, no foreign person, no foreign prelate, no state like United States has or ought to have any jurisdiction or any power or any superiority or any preeminence or any authority ecclesiastical or spiritual within this realm. So help me God, they've got no power. That was included when they brought us immigrants in. The native chiefs signed up and they said that they would let the Queen govern over us, and they would not govern over us because they're not allowed to. So that was the agreement that we've got. And that's why we don't have a Maori Prime Minister. That's why we've never had a Maori Prime Minister. That is why, because they're not allowed to govern over us. Why aren't they allowed to govern over us? Because they've got their own parliament down at the Waitangi Tribunal. That is their own parliament and their own court, and they govern over themselves. They've got their own Tikanga Law Society. They've got everything is their own. And that was the agreement, that they wouldn't be allowed to govern over us. We wouldn't be able to govern over them. But unless you come under the crime where you've committed a crime, that if we beat them up or they beat us up, or if we steal their property or if they steal our property, that comes under the Crimes Act, which was very, very different. That's like the impeachment. So it all comes in there. So that's why there's 60% of foreigners in Parliament, and the New Zealand being bound to any international instrument, that's repugnant to everything that we were promised, all of us. So that's it. So that's all I've got to talk about today, and it's just open for discussions. There doesn't seem to be any bad people in here, and all of you people seem to know what you're talking about and know how to behave yourselves. So so I'll leave it open for all of you to have some chats. We've got here Diane, we've got Jody, we've got Not Norm, we've got Sharon, we've got Maxine, got another lady called Maxine, Natalie, but I'm not sure which one she is, but we'll see if she wants to speak. So I'm just opening it up for speaking now, and I'll be looking at the YouTube.
I think what you've found, Kate, is or what Winston's put forward is actually a key. It's the key to all of it, really, isn't it?
It certainly is.
It's a quick means of probably getting cases through court once the doors are open. You can set that easy precedent. Boom, it's all related to our old laws.
It's all going to get set back to how it was always supposed to be. That we were also always supposed to be allowed to take our parliamentarians to the court and hold them to account. We were also always supposed to be able to do that because the laws that they make concern us. And so they've managed to, you know, people, we trusted the politicians for so many hundreds of years, thinking that they would never do anything to go against us, because we always thought that they would think about their children, that they would think about their descendants, and we always thought that they would be honourable and not governed by greed, but governed by thinking about what they were leaving their descendants with. And so we, all of us, stopped going to the court. We all stopped doing that, and now we've realised that we're all going to have to start teaching our children and going to the courts. So we have to be able to do that. But yes, it's a very amazing case, wasn't it, Jody? Any thoughts, Norm?
Yeah, no, that's very, very applicable to what you're doing there. Very serendipitous, I think, to have find that and have come up with that. Awesome work, Maxine and the team. Yeah, I think it does. I think it opens up the doors quite widely, especially when you've got someone as high profile as Winston Peters putting the stuff through the courts. It just gives it that much more power, doesn't it, really? So, yeah.
Well, the next submission is going to be talking about Winston Peters. They're going to be laughing at our case because we've got Justice Palmer, we've got Matthew Palmer, who is Jeffrey Palmer's son in our first case, in the case. Then we've got Francis Cook, so he's in the case. And then we've got JC McGrath, who is a very, very high up involved with all of this. We've got Peter Gunn, who is involved with, so it is BS that he didn't understand what my case was about. He must have known. So he must have known. What BS, Peter Gunn, that you didn't know what my case was about. So we're going to have Peter Gunn, and I'll have to put a little sneaky thing in there as well, just to let Peter Gunn know that I know what you did, Peter Gunn. And then we've got Justice Brown. Not much, he's not as famous as the others. But now, then we've got, well, right at the very bottom, we've got Jacinda Ardern, Chris Farfoy, Ashley Bloomfield, and that Hipkins guy. So we've got that lineup. Then we've got Palmer, then we've got Cook, then we've got McGrath and Brown and Gunn. Got all of them.
Have you?
Now we've got Winston.
Yeah. I was going to say, have you put in a miscarriage of justice in on Gunn?
Pardon?
Have you put a miscarriage of justice? You could do another case, miscarriage of justice with Gunn. He knew exactly what you were talking about, and he's perverted the course of justice.
There's another thing in there. I didn't go down and read it so far down to you where, or it might have been at the beginning there, where the court, if the court was not aware, of that, or you did say it at the beginning, I think, that if the court was not aware, if the court probably would have been ruled differently had it have been a fair, had it have been
Aware.
had they have been aware, they would have ruled differently. But
he was aware.
I think he was. He must have been.
Yeah, he would have been. He has to be. So that's perverting the course of justice, isn't it?
I don't think so, but we'd have to look at it. But
Not really.
No?
No,
I'm not.
because
no,
remember, we're not trying to get justice here.
True.
So it's probably not. He's just being deceptive.
Yeah.
He was deceptive by
Misleading.
omission, but
Yeah.
I still think it would definitely later, Jody, if we get in the Supreme Court and then we win on the fees, I think that we definitely, if we did get back to the first court, we definitely would be able to raise this issue in the appeal court, Jody. In the appeal court, we would be able to raise this issue because we would be able to say he was deceptive in using the Manic Law to throw us out. So we definitely keep that there, Jody, because that's definitely, absolutely could use way back in the appeals court. Presently, we're fighting fees. Now, I just want to quickly say here, we've got Natalie. And Natalie says, hey, all I follow Kate's YouTube and appreciate her amazing mahi. Mahi means spirit, I suppose. And she says,
No,
sorry for crashing. No, you're very welcome. Didn't realize that this was a meeting. No, this is on the YouTube and this is posted up and you can talk if you want. We're open for talking. So, hi, Natalie. Natalie, do you want to say anything, dear? Does she know how to turn to, there?
Sorry, I'll turn my video on so you can see me. I'm sitting in the laundry.
Oh,
I have to hide and do all my my education on this scamdemic because my husband's on the other side of the fence.
All having problems with husbands, Natalie, all of us.
Oh gosh, he's awake, but he's doesn't want to know about it because I guess he just wants,
a lot of people like that.
Oh, it's pretty scary, isn't it? So, and I just appreciate your work, Kate, because I do follow your videos and about the courts and I appreciate your work. It's quite amazing that 1688 because I have done a bit of reading on it. Yeah.
A proper lawyer could probably do better, but that brings me to the thing that I was just realizing today. If that's in there from Winston Peters, all of those in that parliament, they know all about all of this. They're fully awake and fully aware to all of this. And then that just says to me that National, Labour, the whole caboodle know exactly what they're up to and they're all in on it. Not a single one of them is innocent here. They're all on the same boat. That's what I'm thinking.
Yeah.
They all need to go.
They can't not know. They can't not know.
And Winston Peters is immediate ex-deputy, isn't he? So he'll know what's happening.
Didn't.
He is. But
He didn't know what was happening.
a lot was done behind closed doors.
Oh, really?
Yeah, even he got blamed. He got blamed for signing up to UNDRIP and the United Nations. And it was actually signed a week before he even had to sign up to it. He had to go to New York, but it was actually signed over in Monaco and he didn't even know they were there. I did do a video on it, one of my ancient videos, and I forget exactly what had happened, but he was in New Zealand being accused. It was deliberately set up. He was being accused of something that he didn't do in New Zealand. He was in New Zealand defending that. And while everyone was focused on him, they were over in Mako for some reason with the Danish Queen or the Danish monarch or something, signing up to UNDRIP over there. Now that is going to be interesting because that's going to come up later, but that's in my earlier videos, but that's to do with the Jacobite King, King Ernest Augustus, but we can't go into that today, but that's a whole nother video. But he got accused, but he had to go and sign the official document. The ceremonial document was signed in New York a week later, and Winston was thrown under the bus for that, and he never even, wasn't even him. No, he's been accused of all sorts of things that he didn't do. Although I'm not saying he's the innocent guy here. Definitely not saying he's the innocent guy, but I mean, he's got to pick from, he's not the most popular guy in the room. He's only getting 10%. He's got to pick the party in the room that's going to give him the best seat with the best things that he's going to be able to do, the bits that he's going to be able to do. With the amount of, because they made themselves a law. They did actually make themselves a law when they removed the 1852 Constitution. They made themselves the law that if the major party makes a decision in the parliament, everyone else with the minor, all the minor parties that were given a ministry, all of them have to follow what the major party has ordered them to do. But they didn't stop there. That person is not allowed to tell the public that they were opposed to it. They have to sign it, and they're not allowed to speak that they were opposed to it, and they're not allowed to speak anything about it because it means that they're belittling and demeaning the government of the day that won the major vote. So all they are is pencil pushers. But what they do, only thing that they do get in parliament, they can win on the votes. That's the win on that vote. They are the one that is ordered to sign the document, whether they like it or not, and they are the one that gets accused of signing it and approving it when it had nothing to do with them. So we've got to be careful what we've been accusing some of these minor politicians of doing, when in an actual fact they never would be allowed to do it without the major party ordering them to. So he had to choose between Labor. I'll just quickly go into this. He had to choose between Labor and National in the first vote, but he looked at it. He has said many times he looked at the portfolio of Labor and it looked pretty good. The portfolio never had three waters. Portfolio never had changing the name to Aotearoa freaking Roa. It never had they wanted to change the flag. It never had the three waters. It never had any of that was in their portfolio. Now that's another thing that's up to us, because if something's not in their portfolio, they're not supposed to do it. And so nobody's stopping them from doing it when they're supposed to create a portfolio of what they're going to make their laws and what they're going to do. And then that's what they're supposed to stick to. When they bring in other things, the opposition party is supposed to call them out on it and stop them, and they're not. And so it's not good accusing Winston of that, because he only had this little one seat, 10%. So where was it? So he looked at the portfolio, and then he said to National, what position were you going to give me? And then he said to, actually it was a real setup, the poor bugger. I'm not a person that mentions the word racism. I don't believe in it. I don't believe we've been racist, but I believe in this case, it was a racist activity that they engaged in. I believe that, and I will say it, and I'm not ashamed to say it, but usually I will say, nah, that's not racist. Nah, you're the racist one. He looked at National, he said, what position are you going to give me? And National gave him a lower position. I'm wondering if National and Labor were in cahoots. I can't prove it. It's only in my Kate Floss conspiracy theory. National said they would give him a very low ministerial portfolio, whatever, to my knowledge. Labor turned around and said, we'll give you Minister of Foreign Affairs. Now, Minister of Foreign Affairs meant that he got to go to all the countries and control all the contracts that New Zealand was signing up to. And he thought that he would be able to manage quite a lot for New Zealand when he got that portfolio. And what did they do? Then I think he just walked right into the trap. They pushed the Maori boy up front to be the Minister of Foreign Affairs. Then they gave him some situation to have to deal with in New Zealand for a week, or it might have been over, it might have been, I forget exactly, it's on my old video, but I'd have to go back and find it. They signed up to UNDRIP, and they signed up to the United Nations over in Monaco a week before, and then they forced him to go over to New York and sign the freaking document a week later, and then the whole freaking country blamed Winston, and then they threw him out of Parliament on his ear. So you tell me that that wasn't racist. They shoved the Maori boy up front. I believe in this instance it was racist. I believe that they deliberately used a Maori to do it, and I believe it was a really shit thing to do, and there's nothing we can do about it, but it never leaves my mind that they did that to him, and what a shameful thing it was to do. So don't be going around running down Winston Peters for certain things that he has no control over. Just I don't get into the politics of who you're going to vote up for. I just get into the politics of holding parliamentarians to the account. So that's what I'm focused on. Any more comments?
Just to remember that, of course, Winston will be a target. He's come through Muldoon. Like, who's been there who's seen the whole lay of the land? Yeah, it's him. Dodgy or not dodgy, I don't know. Whatever they say he's been, he's stayed the same the whole way through. He's the only thing that's remained the same through everything. He's the only thing that looks familiar to me if I look back over the decades that as a kid, it's the same. So, yeah, of course he'd be a target. And he survived.
He is our king. Now, when they did the flag referendum, he was the one that fought against it. He fought hard to stop them doing that. And I'll tell you another little couple of tidbits about him that a lot of people don't know that I found out in my little research activities. He is the one that speaks against this word Aotearoa. He has spoken extensively against that. He is the one that he has spoken against the official language of New Zealand being Maori, and he's given us reasons. He said it's the international language of commerce. And all your commerce, all your people are not going to be able to understand the commerce because their English is not going to be up to standard. It's a $1 billion industry, and New Zealand is listed as one of the native English speaking countries. So he's the one that wants to bring back English as being the first language of New Zealand. I wouldn't even mind it being English and New Zealand Maori. I could put up with that. But currently, English is not listed as an official language. Do you know what languages are listed as official minor languages? Hindu, Chinese, all of the 8 islander languages separately in their own right. And English is only listed as the language that people like to speak. It's not.
Surely Afrikaans must be on there.
If they're not there, they're going to be there soon.
Yeah, they won't be far away. Oh,
no,
dear.
they're coming up. We've got a couple of Somalians in our parliament governing over us.
I've always voted for Winston Peters.
I mean, I wasn't throwing him
under the bus.
And,
sorry.
You're not sure I speak.
I thought they all must know about this agenda, but I guess there's quite a few in Parliament that are woke. Is that what you
didn't know
mean, Kate?
about Puapua, and
Oh.
and I have got a very, very old video, and I have done on my very, very oldest video. I don't have time to go back and look because we're too far ahead now, so I just can't go back. But a very old video is of him in parliamentary questions, and when they created the first Health Act, and I've got it in all my stuff somewhere. I told Maxine about it. When they created the first Health Act, they added a 4th article in the treaty to the freedom of religion. Now, America has freedom of religion, and that's why they can have all of the Hasidic Jews and the Islamists and all of that in their country practicing all their religions. But we're a Protestant country, and so we don't actually have freedom of religion, but we have freedom of religion with justified limitations that they can go through the 1990 and the International Covenant, the United Nations Bill of Rights 1990, but it's got a justified limitations of it on it, Section 5, and so that blocks the freedom of religion, so that it takes out all the cruel and unusual punishments, female circumcision of males that is not done by a correct doctor, drinking of the blood, because they cut the foreskin of the penis and they suck the blood from the penis. This is legal in America, and all the babies were turning up with brain, something to do with herpes, because they were getting herpes from the mouth of the rabbi that sucked the penis, sucked the blood from their penis.
Oh, how disgusting.
So that's legal in America because they've got freedom of religion, but that's illegal in New Zealand because we would see that as being a cruel punishment. And so that would come under the cruel and unusual punishment. So that would be blocked by the justified limitations, which is the one law in that 1990, they want the justified limitations removed. So that's the freedom of religion. Now, so we never had that. Now, getting back to Winston, they're trying to say that there was a 4th article of the treaty, and they're trying to say that that had that had freedom of religion. There's never been a 4th article of the treaty. I'll tell you right now, there are 4 articles in the Declaration of Independence, but there was never a 4th article of the treaty. And when they made this original Health Act, they slipped secretly into there that there was a 4th article of the treaty, and they said that that 4th article was a freedom of religion. Winston Peters, in questions, he said, he asked the question, is there a 4th article of treaty giving freedom of religion? And he said, if there is such an article, where is your evidence that that exists? Show me where you got it from. Where is it? And they couldn't show it. So he said, is there a 4th article of the treaty? And they said, we don't know, we're not sure. He said, well, what the heck? Have you gone and created a Health Act that's got a 4th article of the treaty that you don't even know exactly what it says or where it's come from? Why have you put that in the Health Act? And they had to revoke that Health Act and create a new Health Act that only had 3 articles. It was repealed. That was because of him. So he's doing a lot of stuff that most of you aren't even, I'm only aware of it because I went and did some extensive research that took me many weeks to do, to invest, because I investigate. At that time, I was investigating people because I was trying to figure out what you can do. And so but I'm past investigating people, so you have to go and investigate yourself. So I ain't investigating no more. But so there's a lot of stuff that he's been involved with that people are not really aware of, and there's a lot of stuff that he's involved with that he's not permitted to talk about. They're not allowed to talk about the proceedings in Parliament. It's illegal for them to do it. So when there's proceedings in Parliament that they don't agree with, it's illegal for them to speak about it because it says outside of Parliament. it is illegal to talk about the proceedings or question the proceedings outside of Parliament. So they're very restricted on what they can do. So a lot of people don't know that. Right, what else? Throw it at me. Brent, what have you got to say? Say something, man.
Oh, did you tell them about that case, a similar case to Winston's that was came out in Australia in June this year?
Oh, Maxine will tell you about that because she found it. Yeah, go ahead and tell them because that's from you. I haven't even looked at it.
It's it was a similar one. We had a peek at it because my son found it. I don't know why he was looking, probably to try and discredit me. But he found it, and I can't remember. It was some Australian premier or not premier, one of the MPs, Belisaro or someone, and he was challenged by I've got it. Hang on. He was challenged on the same thing. It was parliamentary privilege. They used Article 9, and that was the decision came in June this year. So all these things, and basically what was surprising about it was all these things are popping up in our countries that, you know, like you've got the Article 9 thing, and then you've got Scotland doing what they've done. So all these signals to about the 1688 are coming up, which is, I don't know, I think it's a bloody good thing. But I'll find it. You guys carry on talking and I'll go looking for this case.
What we do, Maxine, is because we're not going to do it today. I was going to do 2 videos today where we were going to talk about the proposed new constitution, and they were going to talk about, we wanted to talk about Scotland also, that's just made a new ruling. But I think we'll just do another video that's maybe next week. We'll do that video. And so in the meantime, Maxine will be able to go and look at that case as well, and we'll be able to bring that in. So we've got 3 cases. So you've got the Winston case now, right? So we've got that. So now we've got to do this Australian case, and then we've also got to do this English case and Scotland's case, and then we've got to do the Jacobite kings. So we've got to do the Jacobites, kings, the Parliament of England, what they've ruled over Scotland, because that's a whole nother video. We do this Australian one. So this 1688 is just going to be coming out more and more and more and more. And so, you know, everyone keep watching the YouTube videos, keep up with what we're doing, and you won't get lost in it. But there's a lot of people, important people, not people like us, but people that are qualified, and they're putting in the right, it looks to me like they see what's happening and they're making their moves. It seems to me they're making their moves now. So, and we're right in there. We're right in there because we're in the Supreme Court. So we're not down there with those common law people with their Facebook. I mean, we're right in the courts with the big hoo-has. It's amazing that we're there. And so our case is going to be all in the history books with their cases. With Winston, we're going to be with Winston, we're going to be with England, we're going to be with all of them. And that's what we're doing for our kids and our grandkids and it's amazing. So I feel quite happy about that.
I need your autograph.
Right,
I need your autograph, Kate
Brian,
Floss, and I'll have to frame it.
Well,
For the
if we
grandkids.
get a win, got to get a
We
win.
will win. We will win.
What we're trying to win on now is fees. We're trying to say that we have the right to petition the king to hold the parliamentarians to account, and all commitments for doing so are illegal. That's what we're saying. All commitments for doing so are illegal. So we're saying that they can't charge us for doing that. We should be able to go to the court for free when it's in regard to parliamentary matters. We should be allowed. And so we're fighting the fees. If we
Absolutely.
win on the fees, that's going to be a win, and we can go and make any cases that we want in regards to that Bill of Rights. And so that's what we're fighting here. Brian Calder's just entered. Oh, okay, Brent first. Sorry, Brian. Brent.
Yeah, I want some clarification. The SNA stuff, right? So people who had land before the SNA came out, did that come out in 2014?
Yeah, let's just say 2014 for a starting point.
So,
Let's just say
right.
it's there. So,
Right. So if they had land
SNA's
before
now-
that, the original contract stands.
yes,
So because I know farmers who have had like hectare after hectare taken away from them under the SNA, and so if they can fight that and go back to the original contract.
yes, and
If so long as pre 2014.
yes.
Yeah.
It only applies, the SNA should by law only apply to, well, you have to be of subject status. See, you've got to be careful because all the people that are coming in and buying the land are Americans, and they're not of subject status, that I keep telling you.
Yeah.
To the New Zealand natives and the Australian Aboriginals, do not let anybody that's not of subject status buy your land in its pure title. See, all farmland is by the grant from the Queen. So the Queen holds the pure title. They give you the tenant for life grant to use that land, right? Well, you are under your subject status laws. But when an American buys that, I don't think they come under the same, I think it's different, and they can get the new contracts with people that are not of subject status, because you've got to be able to use your subject status to be able to enter the court, because these are the subjects' rights.
Right.
Rights, you see. So if they're not a subject, and so it seems to me that it's deliberate that they're selling the land to people that are not of subject status. I don't quite know how that affects the pure land title that sits with the Queen and the native people. But for all the New Zealanders that are New Zealand born, of New Zealand born parents, and specifically and especially ones that can date their ancestry back to pre-1949, when they made us New Zealand citizens, all of you come under your subject status. But that, it dates back to 1865, because that Parliamentary Act says it dates back to 1865, because it was the 1865 Native Rights Act, which said that the Queen's law would be over all of New Zealand. So they're all bound to this. So we've got that contract here. 1865 Native. Hang on. So the 18 Native Rights. See, you have to stop lumping New Zealand in with America, because we're really in Canada. We're with Scotland and England is where we are. So we're coming, anybody dating back to 1865 here, you're all subjects. You don't have to be a subject if you don't want to, but if you want to use these rights, then you need to declare it that you are a subject. So it says there, an act. Can you see that? So it says an act to declare that the Maoris shall be deemed to be natural born subjects of Her Majesty, and to declare that the jurisdiction of the Queen's courts of law extend over all the persons and properties of all Her Majesty's subjects within the colony. But they're selling properties to people that are not of subject status. Americans are not of subject status. Chinese are not of subject status. Indonesians are not of subject status. So they're selling up all your lands to people that are not of subject status. They come under a whole different set of laws, and they're not bound to the 1688. So that I'm not quite sure how all that goes, but so it depends on who they are there, Brent, and what their ancestry is. I think, but well, because it clearly does say they're people of subject status within the colony. So what about the people that are not of subject status? Well, you have to remember that when they originally came to New Zealand, they had to swear an oath to the Queen. When they swore an oath to the Queen, they were subjects, and therefore they were forbidden from buying pure title land. But they were also protected in their tenant status to keep their lands safe from SNAs. But they changed that law a few years ago, where you didn't have to swear allegiance to the Queen when you came into the country. You could just make an affirmation. Now that is very, very dangerous, because the Maori have signed up to the Declaration of Universal Declaration of Human Rights or something, and as Indigenous people, and under that it says that all Indigenous people have the right to a nationality in your states. So they can take all the stateless people out of India or Somalia, all those people that were living on cross borders that have got no nationality. By that, they're allowed to scoop them up, bring them to New Zealand. And since they come under the Indigenous people, along with the New Zealand Maori that they broke the New Zealand Maori in, then they're allowed to get a nationality. They're allowed to get a pure nationality title as a national of New Zealand upon arrival. So what does that mean? It means that if anybody that comes to New Zealand and gets a dual citizen title, so they've got their main nationality and then they come and be a New Zealand citizen, if they create a crime against the New Zealand people that's really heinous or terrible, they can be deported back to their country of origin, to their nationality. But if they bring them into New Zealand when they were a stateless person, then they've got no first nationality, and they bring them to New Zealand and they give them a first nationality of New Zealand. When they rape the woman of New Zealand, when they commit all sorts of crimes, they're not allowed to be deported. When they murder people, they're not allowed to be deported, because their only nationality is a New Zealand nationality, and nationality is not allowed to be removed from them. So that's all done through the Indigenous rights and everything that they've gotten our poor Maoris to get themselves roped into, unfortunately, which is no fault of theirs, because who could have known all of this? It's not their fault. Please don't ever blame them. It's the fault of the people that did these evil things to them. And I am going to say it was the white man. I will say that.
When you say not to, like, there's information there now today to know what you're doing. We're all adults. You know, you can't not take some responsibility in being stupid or greedy or whatever. Like, I've gone in the last month and a half. I've gone back to the year 200 to try and figure out when you talk. So when you talk about the colonizer, I was in a meeting the other day, and you talk about the colonizer. We've seen the paperwork that show us that there's a specific group of colonizer, but when they're going into spaces and teaching teaching about Te Tiriti o Waitangi, which I sat in a training the other night, there, and I was the only Māori in that space. All I'm seeing is anyone with a certain colour is a colonizer. And then when I hit the lady up and said, I think you need to name the colonizer, because according to these historical documents, it was a certain specific people, part of a people, a group, I'm not going to say religions, that came in and played the game. It wasn't all the white people. So you're calling the colonizer, you named a colour. That's what they're doing. It's a colour that they're calling the colonizer, which is, it's not a colour. It's a fucking particular group of people.
Yeah, totally agree.
Are doing it. So that's the lie. That's the lie. It isn't, every white person in the 5 nations that are walking around is a colonizer. Every white person is a colonizer.
It was white people that colonized. It was white people that colonized, so they're lumping every white person as colonizers, and it's not. It's a specific group, like Maxine said.
It's a group.
There were a specific group that wasn't everybody, but it was the second group that joined up with the natives to get those colonists out and confiscate all their lands. It's a whole nother video. We won't go into it today, but
I do want to say,
all the people that came were colonizers. In fact, it was a very, very small amount of people that came that were colonizers, and everybody's been lumped in as that, and that's just certainly not correct. And the natives also had many tribes, and some tribes were working with the colonizers against the tribes that were trying to get the colonizers out. So there's not only one group in any of, and none of them should be referred to by their color, because it wasn't. Yeah, exactly.
So in saying all of that, I just want to make it clear, yes, Queen Victoria took the lands. Ask yourselves why she took the lands. She didn't take them for herself. She still has them in pure title. It was not Queen Victoria that colonized Māori. It was not.
No. The colonizers, that few group of people had come in and taken all the land, and then the natives worked together with Queen Victoria to get all those lands back. So that's exactly how it happened. And we were only...
The colonisers were the 1835 people, weren't they?
Yeah, exactly, yeah. And then all the people that were brought in to fight against them, they were settlers, and they were deliberately brought in by King Tamati Wakanene. It's another video. I don't really want to go completely into it, but they were all brought in to get them out and to combat them against them. So that's why they teamed up with the Queen to do that. So there's actually two groups here. Yeah.
I think also to mention too that, because when I sat there and I listened to this and I watched, and I just thought, if I was in the place of these people being Te Tiriti o Waitangi too, how would I feel? And then when I came home, I was angry. And but if you go to court and someone's stolen off you, and you go to court and they get charged in that, is all their relatives for all the generations going to carry their, their crime? because that's exactly what's happening with this thing. When you go to court, when you get charged for a crime, I would hope that my grandchildren are not going to be pointed the finger at to say, oh, you did it, you did that crime, that you're responsible, because that's what's happening. And Winston's been speaking to that. Winston has been speaking this stuff.
Winston has spoken to, because that's just what we're saying here, is that the group that came in the second wave that came in, none of them were involved with the land issues. None of them. They all came later. And so none of their descendants stole anything. Not a single one of them. Those people bought the land in tenant title, tenants for life, and they were paying rates to the natives from the first day that they arrived. They started paying rates from the first moment. So none of them were involved with any theft of land whatsoever. So they're getting blamed as being that group. But so how do you decipher which one came from which group? Well, the only way you can decipher is if you're a descendant of the 1835 group, pre-1840, those ones that were involved with that, almost all of them were involved with land scamming and land. They were called land jobbers, land sharks, land thievers. Almost all of them were involved in that. There weren't actually that many of them, only maybe a couple of hundred, not many. And are their descendants culpable for that? No, I would say no, but that's that issue. But the next wave that come in on the ships from Scotland, Northern Ireland, and Germany, the Protestants, to get those people out and get those lands back and all of that, they were all fighting right alongside the Maori against those Maori tribes. And then part of the reward that they got, because they lost their nationality when they came, the reward was that they would be able to live in New Zealand under Almighty God's law for all times to come. That was the promise, and that they're trying to get out of that now. So those people were numbered in the more in the thousands if we calculate them up to. So post 1840 through to 1865 would probably, well, right through to 1949 actually, all those people were absolutely nothing to do with the land theft. That was nothing to do with them. So they're all getting accused of it as well. And I'm saying that they were not in that same group. So I don't want it to go into there. I want to leave it with Winston Peters and keep it with our 1688 and how we're able to use that to try and keep what was put in place for us to protect all of us. And who wouldn't want their future generations? I'm not really involved with lands. I'm trying to stay out of the land fight. I'm not involved with the land, gold and silver fight. I'm more involved with the fight for us to keep power over the parliamentarians, hold our government to account, keeping our courts honest, and keeping the ability for us for our children's children to be able to take parliamentarians to the court when their godly rights are being abused, which is the forfeiture of their property, the forfeiture of their person, the shutting down of their speech, the cruel and unusual punishments, the using of parliamentary monies for things that it wasn't allocated to be ruled for. That's more what I'm interested in. The whole land issue is a whole other thing. Although I did bring up the SNAs, and I did bring up, but I'm not talking about individual lands or tribal lands here. What I'm just talking really about is the things that should belong to us as a people, although the SNAs affects all peoples. It affects all the peoples of New Zealand, and even the New Zealand Maori are affected by those laws. So I'm not really focused on the land issue of who got what from who back in that time, because it's not my business. I'm not ever going to get any of those lands because I'm not a Maori. So, and I came on the second load of ships, and so I wasn't responsible for any of that land issues that happened pre-1840. I wasn't responsible for any of that. So I was responsible in getting it back, fighting to get it back. So if you lost it again, that wasn't my fault either. We got it back for you. We can't keep getting it back for you. We got it back for you one time. That's it. If you lose it again, we can't keep getting it back for you. There does come a point when you have to take responsibility and say, how did we lose it a second time, a third time, a fourth time? How did we when we should have known better by now? You know, by now. So it has been lost several times. I think your lands have been lost several times, and I will not deny that you've been swindled several times. But I don't know how to deal with it, so I'm choosing to avoid that situation as best I can. So let's focus on those parliamentarians. I do love Winston. Now, John Wills is coming and Brian Calder is, let's see, is John Wills, do you want to speak as long as you're not a nutter? Do you want to speak? John Wills? Do you want to speak? Probably a nutter, so we won't let him speak. Brian Calder, Northland. Do you want to speak about anything? No, probably another nutter. Right, Natalie's there. Eh? Is he a nutter or not? We've had
Stop
these
calling
nutters.
people nutters.
I reckon, especially after your little spiel earlier on.
Yeah. Yeah.
They're not parliamentarians, are they? They're just like you and me.
So what? You make all these rules for us and then go and break them as soon as you get on bloody camera. You're not allowed to talk about guns.
What's wrong with nutter? You can call
You're not allowed to
people
talk about
nutter.
guns. Oops, I talked about guns.
You're not allowed to talk about guns.
You're not allowed to come onto our chat unless you've got a video on. People have their video off.
They've got their video off, but they're not saying anything, so I won't mind. Supposed to have your video on,
That's
John.
hypocrisy, Kate.
Right, John. All right, Brian
So did
Calder.
did you hear Winston say that the English language doesn't belong to the English? It belongs to you, Kate, the Germans.
He said it belongs to the Germans. Yeah, and he said it goes all the way back to there. Yeah. So there's people. So that's where it belongs to. He said it doesn't belong to England. It belongs to the Germans. Wait till he starts talking about my German settler ordinances. Because we'll put that in right there with Winston. I'll find a way to put, because Winston's name's going to be brought up. So I'll find a way to put that in there. And then Winston might talk about our German ordinances. Bit sneaky of me, isn't it?
Well, he possibly has, through his other lineage, has an ordinance of his own.
He probably
Considering he
does.
talks about his mother a lot.
There are Scottish ordinances and there are Irish ordinances. We'll explain again about them in another video. Does anybody else want to say anything about that, what we've done today? Try and wrap it up, shall we? We're going to come back and do the Australian one with Maxine and the Constitution and the Scottish one and the UK one. So that's where we're doing on the next video. So we're going to wrap it up. Shall we all say goodbye? Great meeting. See you later. Right, I'm going to end it. See you later.